Yes, thank you. Well, both Terry and Jonathan focused on cases in the U.S. courts, and so I'm going to switch a little bit and talk about the cases that come from the foreign courts. That is, there have been references throughout their talks to the fact that there are alternative forum, and sometimes those cases will proceed in those foreign forum. And then the question is, if you get a judgment in that foreign forum, what's going to happen back here in the United States when that judgment is brought for enforcement either in a state or a federal court in the United States? Now, when I was asked to talk about this, I was asked to talk about the enforcement of foreign tort judgments. And I said, gee, the enforcement of judgments is a much more generalized topic than foreign tort judgments. And so they said, okay. But what was interesting to me is that when I looked over all the cases, and I have I'm a school teacher, so what you have in your folder is an outline with a set of cases illustrating these various points. When I looked over these cases, I found very few tort judgments. And the question is, why is that? Well, it's not surprising, and some of that's been alluded to already. That is, plaintiffs, whether they are U.S. or foreign, have always preferred to litigate in the United States to take advantage of discovery, juries, and contingent fees. And if a defendant was successful in having the case dismissed in the United States on forum nonconvenience grounds, that's why so many of them are made, indeed, the case might in fact die if it didn't otherwise settle, because there might not have been contingency fees or class actions in these cases to proceed in the foreign forum. So at least, I think, until only recently, only when the defendant was not subject to jurisdiction in the United States was a foreign plaintiff themselves likely to proceed in tort in the foreign forum. And in those cases, enforcement in the United States was not likely to be important. Now, I qualified my last statement with until recently, because in a number of cases, tort actions by foreign plaintiffs have actually proceeded in the foreign forum, sometimes because the foreign jurisdictions have in fact passed laws. Jonathan referred to shenanigans, and one might, as I continue to talk, characterize this as a shenanigan, to make it easier for foreign plaintiffs to bring their cases in the foreign forum, particularly against U.S. defendants. Now, a number of these laws were passed really in the hope, I think, of preventing forum nonconvenience dismissals by defendants in the United States and putting U.S. defendants in a very precarious position if they decided to try to move the case into the foreign forum. And that was precisely the situation in this very recent case in federal court in Florida, the Osorio versus Dole food case, 2009 decision. And I want to go through Osorio to illustrate some of the important principles of recognition and enforcement more generally. And so those will include basically some just very basic principles about recognition and enforcement, defenses that mandate non-recognition of the foreign judgment, and then defenses where recognition is really discretionary, including the defense that I'm sure you're all very familiar with, the public policy defense. And if I have time, I'd like to say a word about this additional problem of libel tourism and maybe the complexities of enforcing a judgment against a foreign sovereign, but if I don't get to all of it, you'll forgive me. Now, before I talk about Osorio specifically, I just want to make some basic points about recognition and enforcement that were applied in the Osorio case, and they are common to recognition and enforcement practice with respect to all types of foreign judgments. And a couple of preliminary points. First of all, the United States has no bilateral or multinational treaty dealing with recognition or enforcement of foreign judgments. I think David Stewart's going to talk a little bit about an attempt that was made some years ago, went on for 10 years, to have a worldwide convention on the recognition of judgments and agreed rules about jurisdiction, but it failed, and they've come up now with a much more limited choice of court convention. Unlike the full faith and credit obligation, which again most of you are well aware of, that is owed to domestic sister state judgments, foreign country judgments are not subject to the constitutional or statutory full faith and credit obligation. What may be a little curious, at least it's curious to me, is that recognition and enforcement of a foreign country judgment in the United States is a matter of state law, and that's regardless of whether enforcement is in the state or federal courts. Now, the practice about recognition and enforcement is largely uniform, but on some very important points, like the requirement of reciprocity. And reciprocity is the requirement that a court in the United States or a court in a particular state will only enforce the foreign judgment if the court rendering that judgment would enforce a judgment from a court in the United States. And the states differ on that. The reason for the general uniformity is that there's a uniform act, the Uniform Foreign Money Judgments Recognition Act, which is now enforced in about 22 states and territories. And even when there's no act, the common law follows those same principles. Moreover, in 2005, the National Commissioners on Uniform State Law promulgated a revised version of the act. So you have the regular Uniform Act, the old Uniform Act, and now you have the new Uniform Act that's in 11 states. So what does that mean? That means that there were changes made to the original act, and so there are more disparities, if you will, with respect to recognition, and that may mean that the issue of where you seek enforcement of the judgment may well depend whether you try it in New York or whether you try it in Texas. And for a standard like recognition of a foreign country judgment, it seems to me that should be a national standard. Now, I've got a very strong bias on this point because I was a reporter for the ALI project on a proposal for a foreign statute for recognition and enforcement of judgments, in which we suggested there should be a uniform, a national standard to be enforced by the states. So it wasn't to take away the ability of the state courts to enforce foreign country judgments, but to say it should be a national standard, whatever those criteria are, it should be reviewable in the Supreme Court. There has been some interest in Congress on this issue, but I think there's been really no move to a general federal statute. But there is federal legislation, and some of you may have heard about this, to deal with a more specific concern about the enforcement of foreign country libel judgments, often referred to, you'll hear it called libel tourism, or in New York they seem to refer to it as libel terrorism. I don't know whether it was a misprint or whether they really think about it as another kind of terrorism. But the point is that foreign courts are applying their laws of defamation, which don't have our First Amendment protections. And those courts have rendered substantial libel judgments, often against U.S. defendants, even when there is a small publication of material in the foreign jurisdiction. That is, it'll be a national transmission with a little bit of publication. The prime culprit in this regard happens to be England. And in some cases, the victorious foreign plaintiffs have sought enforcement in the United States. In other cases, the defendants in the United States have attempted to preempt any attempt at enforcement by bringing suit in the United States against the foreign party who sued them, asking for declaratory relief that the judgment will not be enforceable. Now, plaintiffs trying to enforce the foreign libel judgments have ultimately been unsuccessful, and I'll talk for a minute, that's the public policy defense. But U.S. plaintiffs trying to preempt enforcement have had less success. They're being dismissed on jurisdictional and ripeness grounds. The judgment isn't ripe, and these people who sued in the foreign jurisdiction have really no connection with the United States other than the fact that they sued in a foreign forum and are causing some effect on that person in the United States. In any event, both houses of Congress have introduced bills to counter the problem of libel tourism, and a number of states, including New York, California, Illinois, Florida, have amended their statutes to explicitly First, to provide for non-recognition of such judgments. That is, we won't enforce this foreign judgment if it violates our standards of speech. And then to go somewhat further and to authorize countersuits for declarations of non-enforcement and indeed the recovery of damages. So that's really a side issue. But I want to turn back to the topic of recognition and enforcement more generally. So there are two mandatory grounds for non-recognition. That is, if these provisions are met, the judgment shall not be recognized. First, where there's a failure to provide for a system of impartial tribunals or procedures compatible with due process of law. And secondly, where there's a lack of jurisdiction, both subject matter and personal jurisdiction over the defendant. There are other grounds for non-recognition that are said to be discretionary, although in practice I think once you find one of these additional defenses, usually they almost dictate non-recognition. I've already referred to the reciprocity requirement, which is one that only some states have. And then there's lack of notice, fraud in obtaining the judgment, conflict with another judgment, contrary to a forum selection clause, a seriously inconvenient forum if jurisdiction was based on transient personal service, and then repugnant to public policy. Now, the outline I provided has cases on all of these points, but I want to talk really about the most important ones and the ones that have emerged in the recent tort cases. The U.S. approach as regards the mandatory ground of non-recognition with respect to this concern that I mentioned about impartial tribunals and fair procedures has two elements. The first is that the flaw must be systematic. That is, it has to be the foreign legal system itself and its procedures are unfair. And that standard means you don't invite an evaluation of the particular proceeding that took place. We don't want a review in the United States of the foreign proceeding. Of course, if there are things like inadequate notice or there's fraud, that would go to the specific proceeding. Now, the 2005 revision to the Uniform Act, and those states actually that now have it, would give greater attention to the particular proceeding resulting in the foreign judgment. It provides that a judgment need not be recognized when the specific proceeding in the foreign court leading to the judgment was not compatible with the requirement of due process of law. So there is a view that maybe you ought to look more closely at the particular proceeding and not have to indict the entire legal system. The second aspect of the defense is that the standard of fairness is an international one. It's not a national standard. It's not the elements of due process that American courts have. And there's a very well-known case in the Seventh Circuit written by Judge Posner, Society of Lloyds versus Ashenden, when he pointed out that it's really whether the procedures that were taken in the foreign court were fair in some broader international sense. And it's in that light I want to look at the Osorio case. Osorio was actually referred to by Jonathan because it was an attempt to enforce a $97 million Nicaraguan judgment in the United States in Florida. The plaintiffs were 150 Nicaraguan citizens alleged to have worked on banana plantations in Nicaragua, and they were exposed to the agricultural pesticide that was manufactured by Dow and used by Dole Food, and it was said to be linked to sterility of the workers. Now, the backdrop of Osorio is also interesting because, as was already alluded to, the plaintiffs initially brought some of these suits in the United States, and the defendants successfully dismissed on forum nonconvenience. So there is this lesson to be learned: be careful what you wish for. Because then, when this case goes back to Nicaragua, Nicaragua took steps of its own to ensure that the plaintiffs could litigate their case successfully in Nicaragua, and the result was a special law passed in Nicaragua aimed at U.S. defendants, which allowed liability to be established in these cases on the basis of an irrefutable presumption. They provided for minimum damages of $125,000. They imposed bond and deposit requirements. They eliminated statute of limitations defenses. They provided for immediate execution of a judgment, and they eliminated appeal to the Nicaragua's highest court. At the enforcement stage in the United States, these retaliatory measures backfired. The Florida court found that the Nicaraguan judgment violated the international due process norms described in Ashenden, and that it permitted these exorbitant damages without proof of causation. It targeted disparate treatment of specific U.S. companies. Its deposit requirements when not complied with prevented an appeal of a jurisdictional challenge, and it eliminated a statute of limitations defense as well as any final appeal. Now, in some ways, a Osorio case is an easy one, given the extreme aspects of the special Nicaraguan law in this case. With respect to other tort judgments, the standard of international due process may be more difficult to satisfy. One point that the court did not elaborate on in the Osorio case was why it was that the Nicaraguan system did not provide fair procedures. We've seen a number of cases where the particular proceeding may have looked unfair, but the courts have upheld and recognized the judgment because they said, well, the system is fair. I think had they addressed the point more explicitly, the court might have said, well, the Nicaraguan law itself violated any sense of fair process. You can't have a statute aimed this way, and that's enough really to indict the Nicaraguan system. But I think that's a point one has to keep in mind, and of course the new act wants to go further and look more specifically at the procedures. One additional complication in Osorio was the point that the defendants had chosen to litigate in Nicaragua by moving for forum nonconveniens, and so the question was there a waiver or was there estoppel? The Florida court rejected that possible defense, noting that the interposition of this law fundamentally altered the legal landscape in Nicaragua, and no one could have predicted when they made the forum nonconveniens motion that such a law would be passed. Osorio also relied upon the other part of that provision in the Uniform Act, which is the lack of a system that provides impartial tribunals. And as other courts have done, the Florida court relied upon the country reports, which are prepared by experts at the State Department, that concluded that Nicaragua lacked an effective civil law system. So these country reports have been very important. Now, a related aspect of the fairness of proceedings and impartial tribunals is concern over possible corruption in the foreign court system. It's interesting that the present Uniform Act doesn't have that kind of a provision, but the 2005 revision did include a new additional defense, which was talked about as the integrity of the court defense, and that can be looked at the individual proceeding. That was a proposal that we put into the ALI proposal, and the uniform commissioners, I guess, thought it was a good idea, and they included it as well. The other mandatory ground that qualifies as a defense is lack of jurisdiction, both subject matter and personal jurisdiction over the defendant. So when you have a foreign judgment, the first thing it has to do is it has to satisfy the jurisdiction of the foreign court. That's first. The harder question is whether, if you have an assertion of jurisdiction by the foreign court, does it also have to be a standard that a U.S. court would agree is an appropriate basis of jurisdiction? And there we have a split. Some courts have said, no, this has to be a basis of jurisdiction that meets U.S. due process standards. Other courts have said, well, wait a minute, maybe U.S. jurisdiction standards aren't the norm, and it just has to be some jurisdictional base that is accepted internationally. This harder question, I think, did not arise in Osorio, because they only dealt with the proposition of whether the Nicaraguan court itself had jurisdiction. But that point turned out to be quite interesting, because the Nicaraguan court already decided that it had jurisdiction, even though the Nicaraguan law seemed to provide that if defendants did not make these required deposits, they effectively opted out of the Nicaraguan jurisdiction, and they could litigate in the United States, waiving any forum non-convenience defense. But the Florida court, when it got the case, said, well, we think this really very unfair. Indeed, there had been an advisory opinion by the Nicaraguan Supreme Court that said that the defendants could opt out by not making the deposit. The Nicaraguan court said, no, we think only the plaintiffs have the right to sue in one of the alternative forums. The defendants in these cases are put in a very difficult position sometimes, because if they go ahead and go on to defend the merits in the foreign court, there are courts in the United States that have said, no, that's a consent to jurisdiction and one that we will recognize. So parties litigating in these foreign courts have difficult problems, I think in part because the law in the United States is very uncertain about when they will recognize certain jurisdictional defenses. The most common defense that one finds here in the resisting enforcement of a foreign country judgment is that of public policy. And this is a defense that you see in every country in terms of recognition and enforcement of foreign judgments. You see it with respect to recognition of arbitral awards, even where there's a treaty. And the cases have held that the erroneous application of law or choice of law is not sufficient to refuse to recognize a judgment. So there is a very, very high threshold, or again, has been a very high threshold, because in these more recent cases, I think we're starting to see U.S. courts decide that they will not recognize a judgment when we have cases with this kind of tort damages that you see in the Osorio case. We're seeing it with respect to the libel judgments where the foreign countries do not have these kinds of protections. And that is a very interesting phenomenon, because it's always been the other way. It's been foreign courts that would not enforce U.S. judgments. They don't like our tort judgments. They don't like our discovery. They don't like juries. The last point I want to make here is the possibility of a judgment not being recognized when it is a penal judgment. And of course, there we have some difficulty in determining. Everybody knows we won't recognize penal judgments, but when is a judgment penal? And courts will look to things like whether the judgment compensates, whether it's meant as a means of punishment, or whether perhaps it's a mandatory fine or a multiplier imposed on the petitioner. And certainly in a case like Osorio, you might well have characterized it as a penal judgment. I think I see my time is up, so let me stop there. I think we are going to see, a reference was made to the issues in Chevron, and I think there have been a number of these cases in foreign jurisdictions where the foreign governments have passed laws to make it easier to bring suit against U.S. defendants in those cases, and I think now the United States is going to have a harder time in doing what it had not done before. It's usually been very, very liberal in terms of recognition and enforcement of foreign judgments. In the libel cases and in these tort judgments, I think we're seeing a second look.